Okay, let's begin with Dworkin. Who is Dworkin? This is Dworkin. This is Dworkin at the beginning of his career. I don't know if you are able to recognize this street, this city, these towers. Any one of you? Let's see. No one? Where is this place? You can put in the chat also if you want. This is Oxford, Oxford University. There is a very famous photo at the beginning of his career because precisely our author began his career there. Began his career with another professor called Everhart. Everhart. Indeed, he was the successor of Everhart in jurisprudence. Everhart was a great professor in his life. He had great students also, and he encouraged all of them to follow their own ideas, even if those ideas were against the ideas of Hart. And that's why his successor, he was a kind of reaction against Hart, but in one way. Another successor that he had, at least a disciple, was John Finnis, a follower of natural law. And now in Oxford University, there are many people that follow, professors, I mean, follow natural law because there is a tradition. But so that is interesting, no? How can a good professor create people in many that has their own ideas? And that's the whole idea of the university. You should have your own ideas, not the thing that the professors and lecturers say is just to allow you to develop your own way of understanding everything. So at one moment he moved to the United States and taught their philosophy of law. And let's see about hard cases, what Dworkin explained following the ideas of Hart. For sure, you will remember this slide. I want just to recap the thing that we said last lecture. So remember the case. There was a sign in the middle of the park that says no vehicles in the park. Okay, for sure you will remember that. Then there were many possibilities. You are the police. A big car, an old car with roof and everything. Obviously you cannot allow that car. Seems to be that you cannot allow. Then a motorbike seems to be, well, there was a little doubt for someone, I remember in the class, but not that much in any case. Then the bicycle, well, there are many kind of bicycles, some of them with an electric engine, others without that. So yeah, there was a great discussion between you, I remember. No? And finally, Bob, who came in his skateboard. Well, I'm a skate. What about the skate? No, seems to be that clearly is not. But there was, for one of you, and in the notion of vehicle, and I remember that one of you rejected Bob, the skate of Bob. So the idea was that the same word seems to be so clear, so obvious. and they are not. Some of them have some level of penumbra, in some cases very high levels of penumbra, and in others, well, not that. It's so easy, no? The levels of penumbra, no? If there is no penumbra, that will be an easy case. If there are high levels of penumbra, that will be a hard case. What we should do in hard cases? Well, according to Hart, I'm recapping. We can do whatever we want. If we are the judge, well, yeah, and there is a high level of penumbra, we can apply discretion. What kind of discretion? A strong discretion. We can do whatever we want. When the higher the level of penumbra, the higher the level of discretion. Do you remember that? I hope so. Well, okay. Dworkin used the same example, a classical example, by the way, to explain. Here there's something that is strange, and that is not working. And more or less, I remember that in the last lecture, some of you got some idea. And he put Dworkin another example, precisely with the same sign, no vehicles in the park. Think about now in a war memorial monument. A war memorial monument of any battle, and you put in the middle of the park one jeep with 4 wheels, with a driver, obviously, and a statue. And a statue is a statue, this one, but there is a jeep, a real jeep with everything. The driver is a statue, and the soldiers are also statues. Well, obviously, and all of them we painted with camouflage. But it's funny, it's okay, in the middle of the park. What do you think? Will you refuse, or will you allow the jeep to be in the park? Remember, you're the police. You're the police. What do you think? Will you allow the jeep with the 4 statues be in the park or not? By the way, remember that I will mark participation, so it's good to answer by chat or by yes, Amelia.
Yes, so if the sign reads no vehicles in the park and there's a jeep, the police would exclude or remove the jeep from the park. It's obvious.
But the jeep is a monument. It's in the middle of the park. That's why it's a monument, and that's why that jeep has. The driver is a statue. It's a war memorial monument.
Then in that case, it does not qualify to be a vehicle, despite the fact it's a monument of a vehicle.
Well, but this is a real jeep. This is a real jeep. I mean, it's a monument, but it's a real jeep.
Yes, but then it, given that it's been put on there it's been purposely put there to be displayed, and it's not going to be driven, then in that case, I don't think it qualifies as a vehicle, despite the fact it is an actual jeep.
But what is the reason that you will allow that? Because what? Just because it is or it is not.
Please, may you rephrase your question? I'm not really understanding the last part.
Well, yeah, okay. According to Dworkin, this clearly is a jeep. It's not about a case of penumbra. This clearly is a jeep, okay? Because it's a jeep, a real jeep. The only thing that is not working, I mean, it's not on. And it says, according to Dworkin, you should allow this jeep. Why? Because the aim of the law, the purpose. Do you remember that was an answer of your class? I remember. I don't remember very well who said that, but I think 2 or 3 persons, 2 or 3 students. So even if it is a vehicle, of course it's a vehicle, you should allow that war monument, because what is the purpose of the law and what is the purpose of the monument? The purpose of the law is to create a good environment without noise, without smoke, without many other things, yeah? And to create a beautiful environment also, no? So you have plants, trees, flowers, animals, and it seems to me that the war monument is not against these kind of things. Instead of that, it's creating a beautiful environment also, no? With camouflage in the middle of the park and these kind of things. No? Okay, let's see the chatter. I have a question. Why is the rule not vehicles? Well, that is the thing. Why is 4? No? I think the reason is justified to inform the decision to move or leave it. The this is a moment, it doesn't, a vehicle doesn't in the ordinary sense. Yeah, but in any case, good guitar. But in any case, I will say, even if it is clearly a vehicle, this is not a problem of penumbra. This is not a problem of penumbra. This is because it fits clearly there. This is a problem of the purpose of the law and of the purpose of the monument. And that's why there is no problem, no? There is no problem. That is very interesting way to understand. Trying to check why things are 4. And then we will understand many other things. Dworkin talked a lot about the validity of the legal system. And he, against precisely Hart, against his master, he said, well, why we believe that this norm is valid? He said, not because it was approved by the Queen, it was signed and published in the country. You remember for sure now the rule of recognition of Everhart, no? He said, there are some primary rules and some secondary rules. The most important one is the last one, the rule of recognition, the way that people recognize that there is a norm in the legal system. Yeah, and he said, I mean, Dworkin complained. That is just a pedigree test. Pedigree test. You check who brought that, who issued, approved, published that, the Queen. And then you realize that is the norm. But this is false. He said, what happened when we talk about, for example, abortion and the laws of abortion and many other things, or some hard cases or controversial cases? Some people will say, no, the law said that, but it's not valid, no, because that is against the human life, no? That guy, someone is dying there, no? at least from this month on. And there will be others that says the contrary. No, this is the body's right of the woman. There is nobody in the womb. It's just a piece of flesh. The things that are there is at disposition, that piece of flesh of the woman. No, but there are arguments, cons, and pros, and that is the way that people use to explain that norms are valid or not. So the validity of the norm doesn't depend only of the pedigree test, the rule of the recognition. It depends on the merits. You should see the merits of the norm. And in these cases that we put in the screen, the motorbike, the bicycle, the skate, and the jeep and the old car, well, there is no discretion at all, as Hart said. In all of them, we have to see what the norms, the rule, not vehicles in the park, is for. What is for? Well, exactly for create a good environment, to rest, for families, for children walking, not a risky one. No, security is also a reason. No, if you have a good, huge cars going in the middle of the park where there so many kids are, well, there will be some problems of security. Fathers will my parents will complain, whoa, what is happening here? We're resting here. There is a car and my baby is in front of the car. Yeah, can you see? So that is very interesting. Another complaint that Dworkin said against Kelsen and Austin was this one. They talk about many things without considering any value. It's a value-free theorizing without any value. And people normally have values. Each one has specific values. I want to protect life. I want to protect women's rights. I want to protect environment. I want to protect security of family in the park. Yeah, and these are the strongest reasons to approve one norm about the validity of the norm we are talking about. Yeah. So, and all of them, Kelsen, Austin, obviously, many others, they are value-free. Value-free. They don't consider the merits of the norm. That is another complaint. So, the reaction. Let's see the merits of the norm to see if at the end of the day the norm is valid or not. It's very interesting. It's a completely different approach. Even it's incredible. Dworkin at one point will write a book called The Morality of the Constitution of the United States of America, obviously. But the morality of the Constitution, and it seems to be a legal book, but the morality, can you see? It's an absolutely identification between morality and the law. It's very peculiar, Dworkin. I don't know if you realize. At one point, someone will ask Dworkin if he was or is a follower of natural law. And there was a doubt. He said at the beginning, well, if you understand by natural law a connection with morality, I'm a natural lawyer. But immediately, soon after that, he will reject that idea. No, I'm not a follower of natural law. And he has a book of morality of constitution, almost identifying morality and law. It's very interesting. On the contrary, there are natural lawyers that don't identify natural law with morality. I think, or law with morality, I think that are two different things, no? Precisely against Dworkin. Well, in any case, let's continue with our guy. No? So the whole enterprise of Dworkin is a critique to positivism. A critique to positivism, because he said, well, that is the semantic thing. No? We divinize the rule, the norms approved by the authority, and we are tempted to believe that that is the only thing that is the law. And it is not. It is not. There are many other things, or ideas, our reason, our conclusions of what is the law also help to understand what is the law and to build the law. Yes, Stacy.
Please pardon from the critique to positivism.
Sorry, can you repeat? Could you repeat, because I didn't get it. The sound was not good.
I'm requesting if you could repeat from the critique to positivism.
Yeah, for sure. So thank you so much for your question. Yeah, for sure, Stacy. So I will explain not just that, but many other things. No, the critique of positivism is that we should not see only the written law, the things that are written. Okay, that we have a temptation to believe that only the case law and the written law is the law. The traditions now are written, most of them in the UK, not in many other places, but in many countries, yes. Let me go ahead. I will explain everything. This is the semantic state. No, we just focus in this, in the semantic, in the form, forgetting the merits, and forgetting also how the legal system was built. This will be a new idea. Let me. So, what is positivism? It's a project of digging out shared rules. No, we found some rules, and we dig in the same rules and try to explain everything with the rules, believing that the rules will tell us everything. Believing, no? Kelsen, you remember, no? Everything is perfect. It's a pyramid. It's a perfect system. Everything with rules. Everything is rules for Kelsen. Hart, well, he tried to overcome Kelsen at some point that he didn't do so much. Dworkin will do a bit more, as you will see. So positivists only see the sources of law, not its merits, and that is the semantic sting. No, the semantic sting. No, just to be aware of the form. Okay. So what do we have to do? What do we have to do to see what is happening? The same examples that we put. Well, we tried to find some reasons. So some principles who apply to this case, even if the words of the written law says something else. Well, okay. law is not necessarily source-based. We have to, well, to decide cases not only with the rules, but also with our understanding, our conclusion, what is happening with this sign, and what is this for. Even probably the legislator was thinking in just these cars, not in motorbikes, not in the skates. But we have also what happened with the war monument. He will never have in mind the war monument. So how to manage hard cases? How to manage hard cases? Because we have to understand that the law is like literature, new idea. This is very interesting. You will see what is constructivism here, because he was a follower of constructivism to some extent, not only, but to some extent. So he put an example. He puts an example of a book written by many authors. Many times when you write a book, you have a previous meeting, I mean, with some authors. You have a meeting at the beginning, and you decide you will write this chapter, you will write this chapter, and I will talk about this, you will talk about that. But he said, no, don't think about that book. You should see, you should think about one book that is written by one author, just the first chapter, but without any connection with any other author. You don't know who will be the next author. And the second author will read the first part. The second author, and we'll see, well, what is happening with the main character, and with the drama, and with the love story. And yeah, it's a novel, no? It's a novel. The second author will write the second chapter. But at the same time, he don't know, he doesn't know who will be the third author. Nobody knows what will be the end of the story. Nobody knows how to end the book, or what is the aim for. Any author will write whatever they want. That is the idea. So the third author will receive the 2 chapters. He will continue the drama, but he will write whatever he wants. So there is no connection between the first, second, third, and so on authors. So if the book is written in this way, what will be the aim of the purpose of the book? That is the question, no? That is very, very interesting, because the whole legal system is written in this way. We believe that there is a strong unity, but it's a construction. It's a construction by many generations, very different authors, very different authorities. Some authorities were the president of Kenya, I don't know, 20 years ago, was different from the president and the authorities and the legislator and the mayors and the judges that are living today. 40 years ago was so different, and now there is another. And all of them are writing a book, the book of the legal system of Kenya. Can you see? Can you see? So what is the legal system? At the end of the day, it's a construction. It's a construction of the ideas of several authors, many times, most times, not connected, because there was not a meeting, I don't know, with Jomo Kenyatta and the current president of Kenya. There was not a meeting to decide what will be the law. Can you see? It's like a book with many authors, without a previous meeting, and without a previous agreement of how that book will end. It's very interesting. It's very interesting. So if that is the book, how we should read that book? Well, obviously with the same ideas, with a constructive interpretation. We receive that, and we are authors of these books. When we have cases, we have to apply the same ideas, the previous chapters of the book, to apply to our specific cases. And in this way, we will write another chapter of that huge book called Legal System. Well, it's very interesting for me, no? So he distinguished here, no? One thing are the rules, but the rules are not the only sources of the law. We have also principles. He believed these principles are moral standards to be observed. The values, the merits that we have in our mind, no? The rules have merits, no, according to our principles, or have not merit at all, no? If the law is against the things that are very worthy in some society, well, this no merit will have. Okay, and he had also that one, the policies, no? Standards that set out a goal to be reached. Well, and that is interesting. Policies, no? We have it also to complete the legal system. We have first rules, then principles, and then policies to reach more or less the aims of each one, of the goals of the authorities, and well, the order in the legal system. Okay, that is Dworkin, sources of the law, these three things. And he will add something. He will repeat many times this, no? The best politics is fraternity. And he will develop an idea not only with the principle of justice, not only with the principles of equality. There was a discussion between Dworkin and Rawls. We will see at the end of this class that for Dworkin, the first principle is principle of justice. For Rawls, against Rawls, Dworkin says, no, the first principle is equality. And not exactly equality, is the principle of equal concern and respect. That is a phrase coined by Dworkin, repeated so often in his books. Okay, we will see that later, just a first clue to the argument. These elements give integrity to the legal system. Now, for Kelsen, which elements give integrity? Well, just the rules. Dworkin said, no, we have to consider something related to reason, to the values of the society, and that will be the principles. And that's why he wrote a book of morality of the Constitution, and policies also, because there are not just rules, but also policies. Well, what it means integrity, that there is no legal gaps, there are no loopholes, it's complete, the legal system is complete. You can find any answer to any case in the legal system. Yeah, well, it's richer, this scheme, obviously, than Kelsen and than Hart also, I think so. But it's interesting and very controversial, this new idea. So if the legal system has integrity, then should have answers for everything. And if even in hard cases, you will have one right answer. One right answer. And that is very controversial. I don't know, have you ever been a judge? Many times you have many possibilities. It seems to be that even in the easiest cases, that is a thing that told me a judge of the Constitutional Court, a Constitutional Court of Argentina. Even in easy cases, you have many answers, because you have two parties. Each party saying, no, you should do that because this, and you see, well, there are some reasons, no? And the other party, no, you should do that because this, you should consider also that. Well, so you have always just one answer, no? And he said, he recalled a mythological guy, judge. Well, Hercules was not a judge, but a character of mythology, you know, Hercules, a very strong character god that can solve everything, you know, very smart. Well, he said, even there could be some hard cases when we should call this god who knows everything, Hercules or great guy, almost God, to solve everything. But even he can fail. Even he can fail. It's incredible, no? He realized that even the smartest guy can fail. So, what do you think about this? Should judges have only one answer or many for hard cases? According to Hart, so many answers, a lot of discretion. Remember that, no? A lot of discretion. Dworkin, no discretion at all. You should have one answer, the one answer thesis. So, what is the right answer thesis? This even Dworkin was from time to time a bit obscure when he wrote about this. So this is a text of Dworkin. These are words of Dworkin.
Okay, so suppose the legislature has passed a statute stipulating that sacrilegious contracts shall henceforth be invalid. The community is divided as to whether a contract signed on Sunday is, for that reason alone, sacrilegious. It is known that very few of the legislatures had that question in mind when they voted, and that they are now equally divided on the question of whether it should be so interpreted. Tom and Tim have signed a contract on Sunday, and Tom now sues Tim to enforce the terms of the contract, whose validity Tim contests. Shall we say that the judge must look for the right answer to the question of whether Tom's contract is valid, even though the community is deeply divided about what the right answer is? Or is it more realistic to say that there simply is no right answer to the question?
Okay. First, Sharif, do you understand what is happening here?
Sorry?
Do you understand more or less the case?
Sorry?
Do you understand what is about the case?
I've not took time to process it, but that's what I was still doing.
Okay, so
yeah,
the case is about the blue laws. Do you know what is the blue laws? Are the blue laws? So it's a kind of religious laws. Religious laws, there are many all over the world. In the United States, time ago, there were a bunch of them related. For example, you cannot do many things on Sunday because Sunday is the day of the Lord. Okay? You cannot have, for example, some kind of drinks in some countries because they are against the religion of that country. You cannot have, for example, meat some days. That is also a law. Was now is not in some places. Here in this place there is a blue law about well, you have to rest Sundays, and if you have to rest Sundays you cannot work, and if you sign an agreement, that is work, and that's why that it's banned. Okay, so there was an agreement signed by Tom and Tim on Sunday. According to the law, that agreement is invalid. So Tom was not so sure about signing that agreement, and after signing on Sunday, the next day he will sue Tim, saying that is not valid. He signed, and the next day he said the contrary. The contract, can you see? So, wow, incredible. So the question here, and I will ask you that question. What do you think? Is the agreement valid or not? Should be the agreement valid or not? What kind of answer? Suppose that you are the judge. Tim is the actor, demand to declare the invalidity of the agreement. What you will do? What will be your answer? Is the agreement valid or not?
If I was the judge, I would say that the agreement is valid, because I think with the wording of that statute saying sacrilegious contracts shall henceforth be invalid, and since the statute is already passed, and from the situation we learned that the legislature is divided on whether contracts signed on Sunday fall under sacrilegious contracts. So I feel like as per this situation, now the decision is passed on to the judge. It's to the courts to determine whether a contract signed on Sunday is a type of sacrilegious contract. So I think I would disagree with Dworkin by saying there's a one right answer, because if the interpretation is open, then a different judge could come to the conclusion that the agreement is invalid.
Yeah, but why? What is the principle that is at stake here? The principle that is at stake is that no one can take advantage of his own fraud. Can you see? So Tim is a tricky guy. I mean, he signed because he realized that he can take one advantage of Sunday, and the next day he said it's invalid. It's invalid. So he's taking an advantage of his own fraud. So if we give the reason to the law, we will declare invalid that agreement. Yeah. But if we realize that with this team will take an advantage that this is unfair, what will happen? Okay, in any case, and you see, there will be some judge that will put a valid answer, and others will reject and will declare null and void. Another will put some sanctions. And so, is there one just right answer or not? So it is the question of Dworkin. Even with Hercules as a judge, there is no just single answer.